Hello everyone, I'm Apurva Pandita and welcome to LiveLaw. In a surprising move today, the Lok Sabha referred 3 bills to the Parliamentary Standing Committee with the aim of overhauling the criminal justice system in India. These bills, introduced by the Home Minister Mr. Amit Shah, propose to replace the key legal frameworks. First is Bhartiya Sanita 2023. This bill seeks to replace the Indian Penal Code, that is IPC. It suggests changes to quite a considerable number of existing provisions and has a total of 356 sections, while the current law, that is IPC, has 511 sections. During his speech, the Home Minister Mr. Amit Shah indicated a major shift in the government's stance on the contentious issue of sedition and stated that the proposed IPC replacement bill, known as the Bhartiya Sanita 2023, would completely repeal the offence of sedition. For a quick rewind, interestingly, in May 2022, that is last year, the Supreme Court had ordered that the 152-year-old sedition law under Section 124A of the Indian Penal Code should be effectively kept in abeyance till the Union government reconsiders the provision. The court suggested refraining from filing FIRs under this particular provision during this review period. This decision followed the government's acknowledgement that the colonial era provision needs reconsideration, as it does not fit today's context and was originally meant for the colonial period. The government had expressed agreement with the court's view. During the last hearing on challenges to the sedition law, the government informed the Supreme Court that they were well into process of re-evaluating Section 124A of the IPC. Coming back to the bill, as stated by the Home Minister himself, there are 313 changes in the new bill. The entire criminal justice system will be completely overhauled and everyone will get justice in minimum 3 years. The bill will introduce that police does not misuse its power. Offences like sedition have been repealed. However, upon closer analysis of the Bhartiya Sanita 2023, the story seems slightly different. Part 7 of the bill, titled Offences Against the State, consists of Section 150, which criminalizes acts endangering sovereignty, unity and integrity of India. Section 150 states, whoever purposely or knowingly by words, either spoken or written, or by signs or by visible representation, or by electronic communication or by use of financial means or otherwise excites or attempts to excite secession or armed rebellion or subversive activities, or encourages feelings of separatist activities, or endangers sovereignty or unity and integrity of India, or indulges in or commits any such act, shall be punished with imprisonment for life or with imprisonment which may be extended to 7 years and shall also be liable to fine. There is also an explanation provided in this section. However, if we look at the currently existing provisions, that is Section 124A of the IPC, which currently criminalizes the offence of sedition, provides as under: whoever by words, either spoken or written, or by signs or by visible representation, or otherwise brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India, shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may be extended to 3 years, to which fine may be added, or with fine. So if we put it simply, the current provision, that is Section 124A of IPC, is deemed to be replaced by Section 150 of the new bill, namely Bhartiya Sanita 2023. Now, if we compare these two particular sections, it highlights some of the important differences. Section 150 uses broader language, covering actions like exciting secession, armed rebellion, subversive activities and encouraging separatist feelings. It also addresses acts endangering sovereignty, unity and integrity of India, a term open to various interpretations. In contrast, Section 124A of the IPC focuses on acts bringing hatred or contempt and exciting disaffection against the government. Talking about the punishment, Section 150 proposes penalties like imprisonment for life or up to 7 years along with fines. However, Section 124A of the IPC suggests penalties of imprisonment for life with added fine or up to 3 years with added fine. The stricter penalty in Section 150 aligns with a recent Law Commission recommendation for modifying the sedition law. Coming over to the aspect of intent, Section 150 requires deliberate intent for sedition and specifies endangering sovereignty, unity, and integrity of India. It includes activities such as indulging in or committing any such act. In contrast, Section 124A of IPC focuses on acts causing disaffection towards the government. Another important thing to note is that Section 150 explicitly mentions electronic communication and use of financial means as methods, acknowledging modern communication. Section 124A of the IPC does not mention any of these specifically. Coming over to the Bhartiya Suraksha Sanita 2023, replacing the Criminal Code of Procedure, that is CrPC, this bill proposes changes to around 107 existing provisions, introduces some of the new ones, and also repeals some of the existing provisions. It emphasizes zero FIR, allowing citizens to file an FIR at any police station regardless of jurisdiction. Ex parte trial and conviction of fugitives, digitization of processes, and video conferencing for trial proceedings are some of the notable features. It also introduces Section 127 as the corresponding provision to Section 150 of the Bhartiya Sanita bill. In Section 127 of this particular bill, a procedure is outlined for cases where an executive magistrate receives information related to the dissemination of seditious matters as punishable under Section 150 of the corresponding new IPC. Coming over to the third bill, that is Bhartiya Sakshi Bill, replacing the Indian Evidence Act, this bill suggests changes like mandatory videography during search and seizure, recording statements of sexual crime victims, and forensic teams visiting crime scenes are some of the key elements. These bills are the result of extensive consultations with stakeholders including judges, law universities, chief ministers, governors, and recommendations from various committees. They aim to modernize the criminal justice system, streamline processes, and ensure fair and effective handling of cases. Well, this was all for this video today. We hope that you like our content, and if you do, then do not forget to like and subscribe to our channel. Now you can also become a member by donating ₹89 per month. Thank you.